Hey, everybody. Welcome back. I'm happy today to be joined by our friend from Law and Crime, host of the Objections podcast, Adam Klasfeld. Adam, how are you?
Doing
Dare I
well. How are
ask?
you?
Dare I ask?
What a day. What a day.
Quite a busy day. And the first thing out of 76 things I want to talk to you about today is yesterday you were in court at the first Lev Parnas hearing. Can you, not the first, right? But one of many.
Opening statements.
There you go. Tell us what's going on with Lev.
Well, one of the key takeaways that I got from opening statements is that we're a long way from where this case began, when we were in essentially the lead up to Trump's first impeachment in 2019. The case was all about Ukraine. It was a case about all the lead up to the plot against Marie Yovanovitch and the essentially to oust the U.S. ambassador to Ukraine in service of this plot to dig up dirt on the Bidens. You didn't hear a word of that from the prosecution during opening statements, nor would you have. Right now, they are telling the jury a very direct story that this is a case about alleged violations of campaign finance laws, and that this is a case about $1 million transfer from a Russian investor, and that this money was funneled allegedly by Parnas to get these marijuana licenses. So they're keeping this very far away from where this case started, which in 2019, this was about a scandal that touched Trump, that touched Giuliani. We heard the last time that we spoke about this, Allison, I had mentioned that the prosecutor kind of signaled that there would be this pivot by saying in court that Trump and Giuliani would be ancillary figures for the jury. And it's very clear that that's what the prosecution is trying to do. Now, when you get to what the defense is trying to do, that's where we get back to the details. That's where we hear more about Trump and Giuliani. Joseph Bondi, Parnas's attorney, referring to him as referring to Giuliani somewhat tongue-in-cheek as America's lawyer, talking about how strange it is that America's lawyer, who's has no fondness for marijuana legalization, is working together with his client, Lev Parnas. Mr. Bondi himself, the attorney, is a prominent pro-marijuana legalization advocate who sits on the board of NORML. And he's talking about these political connections. He's talking about the tie to Joseph Ahern from America First Committee. That's one of the committees where prosecutors say Lev Parnas funneled illicit donations. This is a pro-Trump super PAC. So you have the prosecution now doing a clear strategy, at least in the stages of opening statements, trying to get away from the context, the politics, and just making this a simple case of flouting U.S. campaign finance laws.
And which U.S. Attorney's Office is this?
Oh, this is the Southern District of New York, the reputed sovereign district of New York that Trump, as we know, had no loves lost for, and Giuliani. It was the former home of Rudy Giuliani when he headed the U.S. Attorney's Office there. Now he is under their investigative crosshairs, and that those proceedings are ongoing in terms of their scrutiny of the seized materials that are now going through a special master. It's that Southern District that is prosecuting Lev Parnas right now, and that trial is ongoing.
Yeah, and I was wondering, the reason I was asking is because there is currently a Southern District of New York investigation into Rudy Giuliani and his dealings in Ukraine, which would probably have something to do with Lev Parnas, Korea, Igor Fruman, what's his name, Firtash, that whole thing against Masha Jovanovic, that smear campaign. We know that that's part of the investigation. We know campaign finance is part of that investigation. So it's just really interesting, this sort of pivot away from a bigger picture case to like, no, we're just going to focus on this one thing. And I would assume, but of course I don't know, that might have something to do with the fact that there's an ongoing investigation into the other stuff right now, probably.
I mean, that could be an absolutely viable explanation for it. I think what I keep coming back to here is that in order to get a conviction, they don't need to show all of the political machinations going behind the scenes, which can be a kind of risky proposition for the reason that you state. There is at least an ongoing investigation that we know about that is tied to this. And so we will see if more evidence emerges. Now, it's one thing to not inform the jury about the entire political backdrop, but over the course of a long trial, we will see new evidence come into play. There could be new exhibits that become public that relate to those ongoing investigations. So the devil is really in the details, and the opening statements are generally where the broad strokes are found.
Well, if they ever use a photo of Rudy Giuliani as an exhibit, I hope it's one in front of Four Seasons Landscaping. I just want to put that into the universe, speak it and make it real. I have a couple other questions about some things going on, but I need to take a quick break. Will you stay with me?
Absolutely.
Everybody, welcome back. We are talking with Adam Klasfeld from Law and Crime and the Objections podcast, which is amazing. Check it out. A couple other things going on today. First of all, big news. I went over this in the A block. With the January 6th committee beginning proceedings to make criminal contempt referrals for Steve Bannon, who today failed to show up for his testimony, failed to turn over his documents last week. I was assuming they were waiting for him to not show up to his testimony. It appears that I was correct in that assumption, because today they gave the 3-day notice required by House rules to hold a vote next Tuesday to start this process rolling. Talk a little bit about the process and what you think about its chances of because Merrick Garland has prosecutorial discretion here, and it's pretty rare that the Department of Justice does these criminal contempt proceedings, or maybe they don't do criminal contempt, decide to do civil contempt. I'm not sure, but what are your thoughts?
Well, you're absolutely right that this is a matter where Attorney General Garland has a large degree of prosecutorial discretion. Now, what happens under the statute is that, as you mentioned, the committee will be reconvening on Tuesday. They will vote on whether to find a contempt report. If that contempt report is authorized, that will be sent to the House for a vote. The result of that vote, if that advances, that will go to the Speaker of the House, Nancy Pelosi, who will certify that and send it to the U.S. Attorney's Office for the District of Columbia. Now, here's where it gets interesting. The text of the statute says that the U.S. Attorney's Office will have the duty to, and they shall, submit it to a grand jury for the grand jury to make whatever decision that they will on criminal contempt. But this is where, what does duty actually signal a duty? The Congressional Research Service says jury's out on that.
Yeah. Well, I mean, we were supposed to, the IRS shall furnish tax returns to the House Ways and Means Committee, and we ended up in court, and then that expired. So the whole shall do something thing, I have very little faith in. And I think it would also kind of be maybe a little naive that they wouldn't run this past Merrick Garland, although they technically don't have to.
Right. I mean, the ball will be, assuming that it goes forward, and there's no reason to think that it wouldn't, considering this was advanced by the committee. The House is under Democratic control, and perhaps they'll get even GOP votes on this.
Oh,
but
yeah,
assuming
they will. They'll at least get Cheney and Kinzinger, right?
Right. That's my abundance of caution on, I am prediction averse, that just as a rule. But assuming that this will come to a criminal contempt referral, that's a recommendation. And then Garland, we'll see what AG Garland will do with it. It's essentially, even under that language, he has a duty to, he shall, or the U.S. Attorney's Office for the District of DC shall. Even under that, we have longstanding precedent saying, yeah, the duty means they have the duty to consider whether or not they will take whatever action they want to or want not to take.
Yeah, and and I don't know if it's even feasible or something that could or would happen. I would like to think that it would, that committee might have conferred with the Department of Justice ahead of time to say, are we barking up the wrong tree? Are you going to make us look bad? What's the deal? Because I would imagine, and I know of this having happened in the past where the Attorney General is like, don't bother, I'm not going to do it. And then, they don't do it because it would be very politically bad for them to submit this and to have the Attorney General, the Department of Justice, or the DC U.S. Attorney say, nope, we're not going to put it in front of a grand jury. Now, if the grand jury decides not to indict, that's something that, no one has any control over except the grand jury. Although most things brought before a grand jury, ham sandwich style, usually get an indictment.
Precisely.
It's a pretty low bar, but I'm interested to see what happens here and how this plays out and how long it takes.
Absolutely. And usually whenever there's any sort of development with this, people are often surprised by the process. Just look into what went into a simple, the announcement wasn't that they are referring it for criminal contempt. It's that they are setting up a meeting to initiate proceedings to discuss whether to initiate for criminal contempt. And then it goes a couple of places amounting to a recommendation. So the process, due process can be tedious, but it gets the job done.
And it's always been this process.
And it's important. It's in the foundational principle of rule of law.
Yeah, it's in place to protect criminal defendants because they have rights.
Absolutely.
And, I haven't been able to find a single case where, everyone's like, if this were you or me, we'd be in jail right now. And I'm like, I have yet to find a case where somebody defied a congressional subpoena that, except for like 90 years ago, ended up in jail without this due process. And, there's rules of
absolutely. And this is a check on the legislative branch's power to get an individual in jail. This sort of process, this lengthy process, is an important one.
Yeah, I imagine it will go relatively quickly. I think they'll have the vote, maybe the second vote next week. Maybe they'll give a 3-day notice for a full House vote before they, do the vote. Maybe they won't stack them. Maybe they'll go run concurrently. I don't know if they can even do that. There might be stipulations in the House rules that say they can't, but it seems like at the max, we're looking at a couple weeks before a recommendation is made to the Department of Justice. And then again, like you said, we have to kind of see what happens once it gets in the hands of the Department of Justice. But again, I'd like to think that if Garland weren't going to pursue this, that he would have said, don't bother, do civil contempt, or, just let him sue and take it to court. I'm not going to, do it. But I am worried that Garland might say, I'm going to let the courts decide this one. But I don't know how the courts would decide this one unless he indicted and it got taken to court. But whatever, I'm waiting to see, because as you said, there seem to be a lot of people who kind of don't understand the process, the due process. And as I've said, defendants have rights. And if the shoe were on the other foot, you wouldn't want, and a bad guy were in charge, you wouldn't want to be able to just arrest people and lock them up before a crime is even committed or before due process is given.
Absolutely, particularly when the nature of this investigation, it is an attack on, it's the Select Committee to investigate the January 6th attack on the US Capitol. It's about an attack on our democracy. And it would be a vast irony if that process to fortify our democracy cut corners on any of these things. And as this shows, it is following this process, and we're becoming intimately familiar with this process as it unfolds, probably more familiar than we had been even the people who had been following the arcana for years. Is now it's happening.
Yeah, you can't skirt the democratic process to save democracy. That is
much more pithily put.
Finally, and I think we can probably talk about this more in depth next week, but Supreme Court Counsel, the Commission on the Supreme Court, Biden's Commission on the Supreme Court, just came out with not really recommendations, just sort of, I don't know, thoughts.
Discussion materials. That's how they stylize them. Discussion materials. And the discussion as to court expansion is they are not bullish. They splashed cold water on that idea in as if it looked not very much different, as if the panel consisted of Justices Breyer, Alito, and Amy Coney Bryant, where the idea is that court expansion would reduce the authority of the court by making it appear more politically partisan. The classic arguments against court expansion were embraced in these discussion materials, which don't reach, as you noted, formal recommendations. But there were 5 different sets of discussion materials, and some of the lesser spoken about. Obviously, court expansion is a hot button issue, decried by critics as court packing. And so that's getting a lot of the headlines. But there were other parts that were interesting and significant. The commission appeared to be a little bit more bullish on the idea of term limits for justices. There were ideas.
You can't just make that happen, though. That's
I know.
The
funny thing is,
it's easy to be bullish on shit that requires constitutional amendments.
It's true.
You're not going to.
One of the ironies of this is that the Constitution does not specify the size of the court, but it does specify that they're lifetime appointees.
Well, that's why they're not bullish on the size of the court.
Right.
Because that means it can kind of, there's a chance it could be done, but I'm going to be really adamant about shit that has no chance. I tell you what. Did they say anything about expansion of the federal bench, or is this just a SCOTUS review?
It's a SCOTUS thing. And so in terms of, for example, one of the other smaller recommendations was, and again, it's sort of a recommendation, maybe a discussion material. They said that having public proceedings via audio was a successful experiment, and they came out in favor of that. So of continuing that, which the Supreme Court was doing already. So it was, I guess, essentially patting the Supreme Court on the back for embracing that openness and saying, yeah, maybe in the future, maybe we can have videos, guys. That was actually one of the final lines. They said that, well, there's opposition to videos, but perhaps in the future, maybe we'll get there. And of course, there was a lot of discussion about the shadow docket, and that there had been multiple congressional hearings about that. They seem to be taking some of the proposals for reform and having some sort of mandatory transparency over that. They seem to be taking those proposals seriously without, again, issuing formal recommendations.
Anything about dark money?
The report just came out and it is hundreds of pages. I don't want to say authoritatively, but I did not see it.
Well, we'll talk a little bit more about that next week when we've got a more, in-depth review of the report. And I assume you're going to put something out in Law and Crime about it. So I would recommend everybody look for that. Anything else that we need to talk about today? I think we've covered it all.
I think we've covered a lot of bases. Looking forward to the next slate of heavy news days discussions.
Yeah, as long as it's good news, please. Thanks so much. I appreciate it. Law and Crime's Adam Klasfeld. Everybody stick around. We'll be right back with the good news.